President Cyril Ramaphosa has fired back at suspended public protector Advocate Busisiwe Mkhwebane after she insisted that she'll report for duty today. In a scathing response to Mkhwebane's letter, Ramaphosa says her intention is misconceived. The embattled public protector wrote to the president yesterday, notifying him that because the work of her impeachment inquiry is concluded, she is going back to work.
But in a hard-hitting response, Ramaphosa has outlined why Mkhwebane is wrong in her interpretation of the legal process. He's also stressed that the National Assembly has not informed him of any resolution regarding the Section 194 inquiry. Next week, the House is set to vote on the inquiry's report, which recommends Mkhwebane's removal from office. On the same day, a decision will be made on who will take over the reins from her for a 7-year term. All right, let's bring in Advocate Busisiwe Mkhwebane, who joins us via video link this morning. Advocate Mkhwebane, thanks very much indeed for your time. Your critics are saying that this is yet again another instance of you misinterpreting the law. What's your response to that?
My response is that they are the ones who are misinterpreting the law. And yourselves as journalists, I think you've read my letter. And you've read the president's letter. Interestingly, you're saying it's scathing. I don't know why you have to then sensationalize that. But then if you read my letter to the president, and I've just responded to the president to inform him that the letter which now he has written, trying to bring in the suspension letter into context and indicating that I might have misinterpreted, or yes, he's trying to justify the interpretation of the presidential minute. Presidential minute takes precedence over any letter. Presidential minute communicates the president's decision, and that decision is granted in terms of Section 101 of the Constitution. So I've just informed the President that I'll be returning to the office and I'll deal with all the issues when I am there.
The Office of the Public Protector has also responded, Advocate Mkhwebane. It says that it acknowledges the importance of the subject matter. It's also advising that you are not an employee of the Public Protector of South Africa.
The less said about that, the better. I don't know they respond as what. And that is subject to a lot of questionable, what is their intention? I mean, even the Western Cape High Court did indicate that when they tried to stop the proceedings, the judges were also questioning the acting PP's or the Deputy Public Protector's involvement. I think it's very much concerning to see something like this, but then I will handle a number of issues when I am there.
I see you're still at home, Advocate Mkhwebane. What time are you heading to the office?
I'm on my way to the office now, hence I was saying to your producer, I can't open my video, so I had to do that because he was insisting I'm going to the office.
I'd like to just go back to your opening statement around, whether or not the president's response was indeed scathing. I've got his letter here in front of me. You talked about the presidential minute as well, and the president has responded to that. He says, your interpretation of the presidential minute and my letter is wrong, and your intention to return to office is misconceived. Your letter states that you were advised on 24 August 2023 that the committee had completed its part of the process and that its report would be tabled in the National Assembly. You waited until today to inform me of your intention to return to office tomorrow. Such action is unjustified on any basis. That sounds pretty scathing to me.
I wonder whether that is scathing, is your interpretation, and Unfortunately, I strongly disagree with that contrived and plainly incorrect interpretation of Section 194 and Section 101 of the Constitution. If you can just go after this, and all journalists read Section 101 of the Constitution and understand what a presidential minute means. Those who in the international and diplomatic sphere will understand how important it is. So the president, I was having a media briefing and informing the public about the status of the matter. I mean, the previous chairperson of the committee, Janji, said they are now functus officio, they are now no longer dealing with the matter. And on the other hand, the speaker is saying, no, this matter is going to be tabled. I can't interfere in what the committee is saying. And during the proceedings, during the inquiry, the committee was saying, no, what the president does and what we are doing it's separate. The words proceedings or inquiry in both Section 1943 and the presidential minute do not include other parts of the process. So, as such as the independent panel stage or the tabling of the motion in the National Assembly. So, unfortunately, they are using this, according to Ndumeni case, on which they place a reliance on. The issue here is that the letter cannot take precedence over the Constitution. Section 101 is very clear. So, in the circumstances, nothing in that letter which based the wrong principles of the law, which has wrong principles of the law anyway. So the worst part is that the committee chairperson is saying we are done with our work. And the worst part is that the state attorney and the public protector South Africa office, they withdraw my attorneys and they say the inquiry is complete. Actually, they are even saying the proceedings are complete. You see, so there's a lot of confusion.
Yeah.
The fact of the matter is the presidential minute stands as is. So unless then the president will have to start the whole process from scratch and issue a new presidential minute, because what they have done or his office is very much embarrassing to the president, because the presidential minute, it's like the statutory provision which is interpreting the Constitution. I mean, you can go to war as a country using a presidential minute. So you cannot just willy-nilly just deal with the presidential minute and the confusion.
Right.
So let them go back, read both letters, and understand what I'm saying.
Yeah, so effectively your disagreement with the president is whether the process that must now unfold in the National Assembly, insofar as whether it adopts the recommendation of the inquiry or not. You're saying that that process in the National Assembly does not form part of the inquiry process as a whole. The president is saying he's not been informed of any resolution having been taken by the National Assembly, and therefore it hasn't completed its part of this whole process. And do you disagree with that, Advocate Mkhwebane?
The proceedings and the process are not the same. Hence, I'm saying the presidential minute as it reads currently, that's what we need to focus on. The fact of the matter, I can't continuously to and fro deal with this. The process and the proceedings are totally different. So go back, read the presidential minute. Actually, you should be opening it and go through it and go through his suspension letter.
Yeah.
What is said in the suspension letter, indeed, it covers what Section 194 intends to do from the beginning until the vote of the National Assembly. But then the way the presidential minute is captured, it deals with the inquiry at the committee level. And remember, the suspension was I will interfere with witnesses and I must prepare myself. That they are saying is complete. The others are withdrawing my legal representation. The proceedings at the National Assembly, because remember that is going to be voted on. There must still a process after that, which one needs to engage in to protect my rights.
Yeah.
Has that process been completed? No.
Yeah. I mean, this to and fro that you and I are having is really what has come to characterize your time in office as the public protector, hasn't it? I mean, do you regret that the office of the public protector has become known more for your own legal battles than for the incredible, important work that this Chapter 9 institution is actually meant to do?
That's, again, your own understanding, which is very much wrong. 3 clean audits, doing 95% of the work, protecting the public, which you conveniently, as the media, you don't report on because you are fed this wrong narrative of the public protector not knowing the law, based only on 4 reports of 4 judgments, which I was still on the stand testifying about, poking and showing the public the subjectiveness of those judges who were wrong on facts as well and coming to the wrong conclusions of the law. And I even showed which cases my predecessor as well, where the judgments were criticizing or the judges were criticizing her. But then unfortunately, you are hell-bent to just deal with me and just to portray that narration that I am incompetent. Go back to my work, to the legacy of the office under my leadership, the past 7 years. It speaks for itself.
But the reason why this inquiry was even started, Advocate Mkhwebane, was because you've had these numerous bruising court defeats, several of your reports and recommendations being overturned in the country's courts. That's the reason why this inquiry even started.
How many of those? And how many judgments the judges have lost in court, in the higher courts? And were they taken through this process? This process was just a vindictive process. But hence I said I participated under protest on it. And again, I'm still repeating to you how many judgments are we dealing about. Out of the 412 reports I've issued as the public protector since 2016, and you speaking about how many which I was facing this persecution, and they involve whom? The untouchables, people who don't want to account. Sad reality is that you as the journalist, you just focus on that. I was holding this executive to account. Now, the only thing which is out there, it's only this. And the very same committee, I never completed my testimony. I'm being blamed that I'm delaying, and the legal fees were in fact, legal assistance funding was withdrawn in the middle of my testimony, whilst I've addressed only 2 out of the 5 charges. It's even worse, denying an opportunity for my new attorneys to participate. The SCA matter is still pending before court. The remarks by the Secretary General. I mean, you guys are so hell-bent to just believe this travesty of justice. It's sad.
Advocate Mkhwebane, depending on how things go today, you said you are going to your office at the Public Protector today. Depending on how things go, depending on what happens in the National Assembly on the 11th of September, when that decision will be taken on the inquiry report, what are your next steps?
Actually, it's the predetermined outcome per the late Tina Jumaat-Peterson was the very same parliament. They are proceeding with the late Tina Jumaat, having said this is a predetermined outcome by the DA, the ANC as well, using their numbers, participating in the DA motion. Indeed, that's not the end of the road. This process will have to be scrutinized going forward. I'll still exercise my rights as the public protector. And when my term ends, indeed I will have to consider and take the report on review.
Advocate Busisiwe Mkhwebane, thanks very much indeed for joining us this morning on the AM Report.